to call the meeting to order. My name is Phil Kern. I'm the chairman of this committee. Other members of this committee are Councilman Ben Chenise and Councilman Andrew Upnorth. I know. Also participating in this are the Corporation Counsel Les Pinter, the Director of Finance David St. Hilaire, Wayne Shepard from the Mayor's Office, the Tax Assessor Colleen LaHoo, and Councilman ex officio members Joe Cavo and John Carola. Now, the purpose of this meeting, the mayor has requested for this committee that we authorize and adopt an ordinance that will allow for special tax relief. And by authorizing this measure, we will be providing the assessor with an additional authority that she may need in order to equitably adjust adversely affected properties. Now, the way I'm going to, normally we don't allow anybody to speak at these meetings. However, I feel that at the end of the main participants that we're going to question, I'm going to allow the people from the public to speak. If you come from a, I don't want to, if you're from the same neighborhood, I would like to have one or two people speak, not everybody from that neighborhood, because you're just going to be repeating yourself. And if we do adopt this, it's going to end up going to a public hearing, and that's open to anybody speaking that wants to speak. So I'm going to start off by asking Director of Finance, David St. Hilaire, to tell us where we are, or where we're headed.
Sure. Thank you. Basically, back in, I believe, July or August time frame, we received a number of calls and complaints targeted specifically around the lakefront properties about their assessments and about there being some inequities in that area. Of course, we always hear those kind of concerns around any, redial time. So there's a process that's built in for that. But there was an incredible amount of phone calls and concerns, and we met with some members from around the lake, and we decided, we got to take a look at the whole, do an analysis of the whole grand list, because we can't just target one specific area. So we went through an analysis of the grand list, which is 30,000 properties, about 12 to 13,000 specifically for residential, which is 101 class properties, and to look for some kind of, if there were trends, if there were some odd things in there, where they might be, and if they were kind of in a cluster or not. After a lot of analysis, we identified that there were a bunch of clusters, and most of them specifically around the lakes. So we said, well, we noticed we had some kind of issue there that we could not put our finger on. It really, there wasn't a clerical issue. We had discussions with Vision about those things. They followed their manual as they're supposed to. From a mass appraisal standpoint, it doesn't make up a whole lot of properties. We're talking about, in the lake area, there's probably about 800 or some odd properties on those streets up there, but really the problem clusters are about 8 clusters with about 173 properties. So we went a step further, and we hired a consultant to take a look at it. Actually, 2 consultants. The first one did more of a financial analysis, a comparative analysis of all the data, again, starting with the entire grand list and finding out where the problems reside. And he came to the same conclusion that I came to. And we discussed that, throughout with the assessor, Corporation Counsel, and we shared some of those thoughts or conclusions, not specifics, but general conclusions with some members from around the lake. We recognized that there was an issue and a concern, and so we contracted with Cushman & Wakefield, a firm that we routinely used in the past to do valuations in our tax appeal cases, and we gave them the data. And we asked them to take a look at it. And they came to, again, a similar conclusion, because we have to be careful when we're looking at these kind of situations, that we're just not knee-jerking to complaints when a reval is done. So we're very deliberate in how we approach this, and very concerned that we respect the integrity of the process. But, you know, they came to a conclusion as well that there's something going on here that doesn't seem to make sense. It defies logic. And I think some members from around the lake area have shared their own analysis with us. Coincidentally, they came to a similar conclusion they didn't have the luxury of looking at the entire database that we did. But their conclusion was pretty close to what we came up with. There was an issue apparently with the land values. Not exactly sure why, but you know, which affected, of course, the overall values. And we met with our Cushman and Wakefield to discuss, you know, what remedies we could, you know, legally. We met with the Corporation Council and said, what can we legally do that, again, respects the integrity of the grand list and the process that the assessor must follow. And that's what's before you tonight, is after a thorough review by Corporation Council, because it's not a straightforward clerical error. And that's something the assessor can take care of right away. There's a, no one will ever say there's a flaw in the mass assessment appraisal process, but there's some issue that you can't really put your finger on. We just know there's an issue, and the numbers show that. So the question is, you know, how do we address an issue that, you know, where one resides to hopefully not exacerbate or make an issue worse. So there's some remedies that are before you to consider. It's not gonna, I'm gonna tell you, it's not gonna make everybody happy, but it's a step in the right direction. It's a balance between, you know, the assessor, the statutory requirements that the assessor has to follow. And we have other things that, from the city standpoint, we have to follow. And that's why we looked at it. It took a while, because we have to do it from a total grand list perspective. We can't look at, yes, you guys, you all banded together and came in and therefore we're going to change. No, we had to come to it from an independent standpoint and say, do you have validity in your issues? And normally we would say, you've got there's a process for you. And that process traditionally works very well. But I don't think we've ever had such a large group in isolated clusters that have had these issues. And that's the bottom line. That's why this is being dealt with differently than in times past. But that was a process. It's taken some time, and a lot of people have been involved to try to come to a process that can hopefully minimize I guess the increases that the folks that are concerned have. And we're still going to have to look at it individually, but this will give us the ability to make some modifications that are not clear-cut, such as, you know, it's a clerical issue. In other words, a factual change, such as the square foot on your house is listed as 3,200, when in fact it's really 2,800, and therefore your assessment is reduced. It's not straightforward like that. As I said, the assessor could have made that change. Anyways, and that's achieved.
David, one of the reasons that some of these taxes jump so high was because of the phase-in situation?
Well, yes, thank you for bringing that up. One thing, we focused on assessment because really the assessment drives taxes, and really there are a couple things that affected the taxes in the last go-around. There was a loss of the phase-in. If you recall, there was a phase-in during each of every year of since the last reval from 2007. And so the property values were about at 62.25, is that about right? And normally it would be at 70% of fair market value. So said another way, if your house value is $100,000, your assessment value would be $70,000 under normal circumstances, but with the phase-in, it was valued at $62,500. So now you're taxed on that piece rather than $70,000. Why did we do that? Quite frankly, to recognize the steep decline in the market from 2007, and it was determined, after again doing market analysis, that it was best to keep it where it was because anything else would artificially inflate prices and get us further away from where we ultimately ended up. And we all know that property values on average, across the roll dropped 19%. Our grand list dropped 19%. So fortunately, we didn't put that last year in. It would have made matters even worse. So that's one piece of it. The other piece is related to the mill rate itself. And the mill rate is, went from 22.45 to 26.8. And that didn't really generate that much more revenue. I mean, it sounds like, wow, that's a big increase. You guys are swimming in additional tax revenue. That's not the case. And the reason being is because there's a shift of the, basically a shift of who pays what taxes in the city. You got your residential, you have your commercial, you have your industrial. And so what happened is there was a big shift. And when that occurred, we had to make sure that at a minimum, we were able to raise enough to keep the city running. Now, even if we were to keep it on even keel with the mill, with the previous year, the mill rate would have gone up to about 25.8 or 25.9. I think it's 25.9, without even getting a nickel increase in tax revenue because of the decline of the grand list as a whole and the redistribution. Okay, so if the property values went down for your overall, just to say something about the residential, on average, residential properties declined 25%. 25%. So when the folks around the lake are saying, my assessment or my property value assessment is at it didn't change from the previous year, they would have seen an increase in taxes because of the mill rate, because of the loss of the phase-in, just because even though they stayed the same, because proportionately now they have a larger share, and that would have equated to about 30%. 30% between the two. And unfortunately, there was no way to avoid that. From when you look at the overall city, I know this isn't going to sound fair to you guys, but when you look at the overall city, the residents, as we mentioned last year, most of them went down. On average, went down from the tax revenue derived from residential properties. Unfortunately, there are some that got hit hard.
Is it too, I mean, what is your solution then? Is it too early to ask that?
Well, I think there's a proposal that we have from Cushman & Wakefield that recommends a 20 to 25% adjustment in the land values of those properties that have been identified. There's about 173 or so. Now, not all of them may get that because there may be certain situations in which there's good reasons why their land or why their overall values are what they are. Maybe their property sold for $700,000, and because of this formula, it would drop it down to $600,000. You can't very well do that because there is a good comp there, and really the effort is to try to make things more equitable. And the part of the problem with the lake properties is you didn't have a whole lot of comps to start with. Not a lot of sales happened up at the lake. And so they were using the few comps that they had, sales that is, And those may not have been the most appropriate in all situations up there. So that is a option on the table, and again, we have a identified group of 173 that many of them may be eligible for that, but we can't say everybody is on that list at this time yet.
Councilman Shanese?
Just through the chair, before we get into the actual proposal, I just want to get an idea of what you said. You mentioned that you kind of clustered the homes together. And
I didn't cluster them. That's the way the numbers worked out.
But you came up with 8 clusters. Can you identify what those 8
Sure.
clusters are?
That is it. This is the one from yesterday, right? Yes. Did you go all the way down? Okay, that's it. Shore Road, Pocono Point, lower 40-acre Mountain Road, upper 40-acre Mountain Road, upper Neversink, lower Neversink, Moody and Zetagan, Boulder Ridge and Sunset, Hillside and Waterview, Premium Point, Sunset Cove, Oak, Reynolds, Settle, and Briar. Those are the ones that had the most significant and obvious issues.
And that was, again, through the chair, and that was particularly just based on what Cushman and Wakefield came up with?
Yeah.
Do they do the entire city or just the lake?
No, we started off with, the analysis started from the entire 101 class, which is about 12 to 13,000 properties. And then you basically look for anomalies in that, and then said, all right, what's going on with this? And you basically sort different columns and you figure out what's falling out. What seems normal, what doesn't. And these did not seem normal, and then you start looking at the pieces. Actually, there are a lot more that didn't seem normal, but when you look at, maybe there was an addition, maybe there was, a good reason for a change, you start eliminating those. And then you look at, so you're comparing apples and apples from 2000 and the prior grand list to the new grand list. And we're able to feel comfortable with about 173 properties that we could explain.
So you can do the chair, so you base it on from the previous grand list to the new grand list, so any homes built
Yeah.
that wasn't on the old grand list would not be affected. Or would not
Right. If
require
it's a
this
new home
study.
since 2007, they're not gonna be on here.
Thanks.
Again, just to mention though, there is a process for them to go through if they have those concerns. And, they have until, February 20th to file a appeal, which they would go before the Board of Assessment Appeals.
Most likely unless there's a clerical error, they most likely would not have that assessment change. Unless, of course, they went out and got their own assessment.
And that, we've seen that before too. And just one thing I did not mention on whatever, if a remedy is as proposed, if we move forward on that does not, eliminate them from still going forward through the tax appeal process if they choose to.
Les, I have a question for you. About this ordinance, could you explain it and what the purpose of it and what it's going to do?
Thank you, Mr. Chairman. Just to preface that just a bit, Mr. Chairman, one of the difficulties in this particular case was, given the statutory and administrative duties of the assessor as well as the director of finance, this council and committee, and the people who were affected, created one of the most unusual problems and resulted in one of the most unusual remedies, and that's what is proposed here for the council committee to consider. Simply put, the assessor has certain statutory duties which is faithful to director of finance similarly. The problem is an unusual one for a number of reasons. I'll go into in detail if you wish, but let's say it this way, that the 2012 list was a revaluation year. The perfect storm included not only the revaluation of properties, it also included the adjustment of the mill rate, as David said before, as well as the phase out or the phase in. So that storm occurred and results in an unusually crafted remedy. But the ordinance would provide this committee, if it recommends it to the full council, what it would provide is to allow, by specific enabling authorization, for the assessor or the director of finance, as the case may be, and you'll see there are 3 options available. And by the way, you do have a revised ordinance in front of you that's highlighted for you so that it's clear to you what changed from what was submitted to the council in the summer. And what it provides is a remedy that may be implemented either by the assessor or by the director of finance in the event they determine that relief as requested should be given. The assessor can avail herself of either the clerical adjustment that's provided by statute, which she already has in her possession, or she can use a statute that permits the adjustment of an assessment and thereby tax relief that's provided for in the reference statute, where properties of a particular class, i.e. residential in this case, were for whatever reason unequal or found to be unequal. And the third remedy is that if neither of the others is available or usable, then the director of finance would be provided the ability to secure some additional tax relief and provide the relief in that fashion. There's nothing here in this ordinance that will tell the committee or the council exactly what the relief will be. What the ordinance provides is that relief can be secured if the department involved finds that there was an inequity and finds that it is in the best interests of the situation to provide relief. So if you adopt this ordinance, you will be enabled to authorize these departments to remedy what from the facts and reports available seems to indicate that there was some inequity off the 2012 revaluation as to this class of clusters of property. Now, if the council adopts this, it's somewhat unusual because normally the assessor's tasks are left to the assessor. However, we have found law, and we also have an opinion, a written opinion that supports the propriety of adopting this ordinance. So if you do that, our opinion is that the council is authorized to provide the departments with the necessary tools to make those changes. So that's what the ordinance before you looks like. And again, the modifications to the ordinance that you have tonight include references to relevant statute sections and adds a provision permitting the director of finance or the finance department to secure tax relief as tax relief as opposed to assessment relief. That's about it, Mr. Chairman. You can answer questions as they come up.
Yes, go ahead, Councilman, please.
Thank you. So, I'm confused. So, given an example, let's give an example, so we can apply what was just said. Okay, so if I have a 28,000 square foot house and I live on the west side of town, and there's another 28,000 square foot by the lake, we both have equal sized land and everything, whatever. So, generally what happened is my house was appraised hypothetically $800,000 back in 2000. It got revalued in 2012 standard, and it got dropped down to 600,000, which is the 19%, would have done, was it 25% on average decline. So my house would have went down. So I'll get mine, and the mill rate cost went up by 4 mils, so we know that. So in theory, my taxes would go down overall, would go down if the math works right. But the lake house is valued at $1 million, but their assessment only went down to $9,500,000. So they will only get like a small decrease, say 10% decrease, but that mill rate would have went up by 4%, but they would get hit with a larger tax increase than I would get hit. Okay, and that's basically what I think what's happening here now.
Right.
So how would this remedy help them? What would they do?
Well, I think in a situation like that, I mean, it comes down to, was there any inequity to begin with? I mean, keep in mind, those streets that I mentioned, those clusters I mentioned, there's actually about between 800 and 900 properties on those streets. So we're not talking about every property on those streets. We're talking about, you know, on those streets, there seems, when you're looking at the numbers, there seems to be some, you know, either the land value in proportion or in comparison to their, you know, their neighborhood doesn't make sense, or the overall property value doesn't make sense in comparison to the neighborhood. But there are reasons why it stood out. And, you know, in some cases, it's, you know, it's a house right next to each other or right across the street from one another with no discernible difference. You know, yes, it may have a different paint color, but no real major difference there. In your situation, you have a location difference. I think we can acknowledge that it's likely that the property values at the lake retain their value more so than others around the city, and I don't think that's not the issue. So, you know, we're just trying to make things more uniform in comparison to others, the best that we can. And the thing that does stand out, when you weed out all the noise, you know, additions and any changes in the property, is really the land values seem to be more heavily weighed than perhaps the structure itself, in most of the cases that we looked at. So, you know, I think if you're trying to use your example from a comparative standpoint, it would be difficult to say, all right, you know, we've got two houses, one on the lake, one not on the lake, and the one that's not on the lake saw a larger decrease, which makes sense, you know, not on the lake, but in the one near the lake, maybe it makes sense, but you don't know until you look at that specific property and the breakdown of the structure and the land in comparison to others. So you can't just say, yes, we're going to do this. That's why, you know, we can't tell you exactly how everything's going to work out for an individual property tonight.
So, okay, through the chair, I just want to get an understanding. So again, the house on the lake, so, I mean, granted, there's the value of the land.
Right.
And no matter if that house was gone, that land has a value.
Right.
So if you took all the homes away,
Right.
and just had the land and carved it up in quarter-acre lots or whatever, the land value should be constant throughout the whole lake. You won't see much difference in the land value.
No, that's not
The
necessarily the
rental
case, because you may have some that are on a steep area that certainly may not be valued it's gonna be valued differently than somebody that's not on a steep
So
area.
that's one of the first steps you will do, is take each piece and
You
look
have,
at it.
that's why you tend to look at the initial surroundings, and, you know, you work your way from there.
So a house on one side of the road, the neighbors would be about the same value.
In theory, yes.
So you won't have one house valued higher than the neighbor's house, which is.
Without, you wouldn't have
Without
a
any-
without a discernible explanation, you know, something that says, well, you're on a steep, you know, you don't really have a yard, but it's very steep, and the other property is all flat land. You know, the one that has all flat land and they're the same houses, chances will have a higher
Yeah.
overall property value.
So, okay, so it does happen, there is a difference, you've determined that there's a difference.
Yeah.
How does this
Yeah.
ordinance help? Yeah.
Well,
What's the next step now?
The issue with that is, there's no clerical issue.
No clerical issue.
There's no clerical
It's
issue.
strictly evaluation issue.
It's strictly evaluation, and keep in mind, from the perspective, from an overall financial perspective, not an assessor, so I'm not doing it from the assessor's standpoint, but, you know, you look at numbers and you have to, they have to make sense, there has to be some logic to these things, and, you know, whether it's proportion or, you know, some rhyme or reason to the numbers. When you see a property significantly higher than another property, and there's nothing that really stands out on that, you gotta ask, all right, does this property have, you know, exclusive access, or, you know, what other factors may come into play? And we've kind of gone through a lot of that right now. So that's not the issue. So we're left with just a uniformity issue. And we want to make sure that, you know, we're trying to be as uniform across the board as possible, because it's administratively burdensome to have everybody come in and try to deal with this on an individual basis going forward. And it makes quite frankly, it makes the grant list unpredictable. And you know, as you know, we have to get a budget together fairly quickly and go with those numbers. And if we're, you know, in addition to the 50 commercial properties that we have to deal with from last year, we're dealing with another 170 other properties. You know, it makes it, from a financial standpoint, very difficult. You know, so how can we best administer a problem we acknowledge? That's what it comes down to.
So, I mean, so what would happen is you would take, the resident will come in
Yeah.
and see yourself.
No, I
The
mean, it
application
really,
process, how would they?
we're still trying to work out that piece of it, but I am not gonna be you know, the
Hearing officer.
right, I'm not the hearing officer, it doesn't work like that. I think, you know, that's a process we're still going through, but we have what this ordinance allows is you know, the 3 levels, but we still haven't defined the procedural aspects of those. Is that about right, Buzz? So,
But again, I'm just trying to figure, so this ordinance will allow you to say to that individual that I can take $50,000 off your assessment, 60, whatever you determine.
no, I don't adjust assessments.
So what-
It's a tax, it would be a tax adjustment.
Tax, the physical tax.
Right.
So if their tax was
Right, based-
$20,000, I can take 1,000 off of 20.
It would be, yeah, I mean, that's probably the simplest way to describe it, yes.
So it's not the assessment you're adjusting, it's the actual tax that's coming up.
That's right.
So you're gonna give them like a tax credit.
Right.
If they qualify on the.
Yeah, I mean, the ideal way is, again, through the assessment process, because the tax credit is really just to deal with the initial immediate problem that we have right before us now, and that is, they have to pay taxes this year based upon an assessment value which is in question, which appears to be a problem in comparison to others. Then you have the other issue of going forward about, you know, how do we deal with those from, you know, assessment standpoint. Is that about as funny? So we got really those 2 issues, the immediate one, which is more of the tax credit related issue, And then going forward, which we hope that if people are, still have an issue if we take a couple of those remedies, which would be an adjustment that would, dealing with the land value of 20 to 25%, combine that with the tax credit, then perhaps you don't need that other one after that, because that adjustment of land would be would take it going forward as well. Because that does affect the assessment. But that's something that we would work with the assessor's office to obviously, work through all those, because you gotta look at each individual property.
And everything you just said, again, through Corporation Council, is in this ordinance right now.
Yeah, just to speak to that, Ben, what you won't find in the ordinance is the excruciating detail of how the breakdown will occur. We have a class of properties, as David explained, and those class of properties will be examined for the remedy that is available for them. And then, once the individual property is examined, then there will be a proposed remedy that will be looked at to achieve the goal of securing some tax remedy for the people who are affected by this inequity. So what you see is tools that will be used by either the assessor or the director of finance or both, that they will use, it's available to them pursuant to this ordinance. After any adjustments or remedies are affected, you and anybody else will be able to see what the remedy that was given. This gives them the authority to use those tools in a way that they would use looking at the facts for these properties and each property.
Does this give the tax assessor more power than she has now has, or does it give her more cover?
Both. What it does is it gives her, she already has inherent statutory power under the clerical. She already has that. The other remedy, which is pursuant to number 1 in the ordinance in that section, uses a statute that is very rarely used. It does require, I should say, the legislative body to adopt the ordinance to allow the assessor to use that provision. And that's the provision that permits, in essence, after an examination of the situation, to provide a specified minimum tax adjustment for those properties, those residential properties that have been deemed to be, if you will, harmed by an outsized or excessive assessment. On the basis of a law that was adopted by the state legislature to allow for this, but in order to implement that law, the local legislature, you folks, the council, has to adopt it in the form of an ordinance in order to implement that. So that's that prong of the ordinance. So going back to the question, the assessor, that would give the assessor additional powers by act of this legislature, of this city council, and it would allow her that cover, if you will, and that authority.
Colleen, how do you feel about all this?
Well, as Les stated, I do have to follow the law through the state. And part of that law is to revalue the properties. And so in doing that, we had the 2012 revaluation. And the other part of that law is that everyone is to be notified of their new assessment, which they were. And on that notice, it also stated if you were in a dispute of that new assessment, that you had to go through the board. And I believe what has happened is people have got their notice and were okay with their assessment until their tax bill came out, which was in July. There might have been people that appealed. I don't know what the outcome for the lake properties were, if there were any that have appealed, but that's the law that I have to go through. And the reval is mass appraisal. And this, I believe, is spot assessing, which I do not feel is legal. And that is just my opinion as an assessor.
Thank you, Mr. Chairman. Through you to either Mr. Pinter or the Director of Finance. These assessments, there's, just to be clear, there's no way to go back and undo what has already been completed, or the tax bills that are there. There's no way to go back. These have been collected, and it is what it is for the previous year. We can only move what we're doing from here forward, correct?
Right, I mean, as I mentioned, and let's just, let me know if I'm mistaken on what's being said here. There's, you know, the tax credit will help deal with, the initial tenant is for the current year on that. However, that can be used for going forward. You know, so, you know, we can't undo what's been done, but we can deal with it through that means. And the other process is, and we hope not to do every one of these individually, is to hope to, you know, look at these 170 and try to deal with them in groups and say, all right, you know, this, you can make this kind of adjustment for this street, or this kind of adjustment for this street, and deal with it in that approach, and hopefully in cooperation with the assessor's office. So, but you know, that's, we can't undo what's been done. We hopefully, you know, can take care of it for the current year if this is passed, and hopefully going forward. You know, there's of course the current remedy, which is the tax appeal process, but this offers, you know, acknowledges we accept that there's an issue.
Let me have a follow-up through the chair. Thank you, Mr. Governor. When you're going through this process with vision appraisal, so they come with their decision on a grand scale, there's certain clusters. Have there been evaluations that we found on our end that were actually too low? Has that never come up before, where this would be on the reverse end?
Well, the assessor would deal with vision in that regard, but to answer your question, yes, we've seen that in situations. So.
And how did we rectify that problem to you, Mr. Assessor?
Well,
they just gonna be they're not complaining.
Once the revaluation is completed, we have to, there's certain tests, standard tests that have to go through, has to go through the state of Connecticut, saying that each property is at, you know, 70%.
Mm-hmm.
And all of those test measures are sent to the state, and that's what we sign off on. Is 26,000 parcels absolutely correct? No.
So, but through your opinion, you deem it okay
Yes.
to find that people have low appraisals, and it's okay to make sure that they're ensured that they are, in your opinion, equitable to everyone else, but not
Right.
the other opinion in this case.
Right, and, well,
So it's okay for the city to get this to
No,
that,
I
but not
mean,
for
if-
the other folks.
no, if there was a sale on a property, let's just say there was a sale on the property and his house, it was for $1 million.
Mhm.
And we had the value at 1.3. That's a flag to me.
Okay.
There's something wrong.
Mhm.
It could be the land, it could be the building, there is a problem. If that same property sold for $1 million and the assessment is 800, 850, I say that's within reason.
If I may again through the chair. So if we were to pass this ordinance here tonight, you would, in your capacity, and would probably choose not to implement anything here. And I guess that's part one, and I'll follow up through Mr.
Okay.
Is that?
I feel that, you know, the 171 properties that we're doing these on an individual basis, and the reval is not an individual property, it's a mass appraisal. So if somebody went to the board, they would have gotten a lot of people get an appraisal. It's not a mass appraisal, it's an appraisal because it's one, and that's what they're presenting to the board. So in this case, I feel that, okay, their assessment went up, their assessment went down. In some cases, the assessment went down, it's just between the phase-in and the mill rate that their taxes went up $3,000 or $4,000, and it had nothing to do with the assessment.
Any
So
other-
how would you alter that?
I guess it'd be through this. So I guess, and then, I guess again to the chair, or Mr. Pinter. So, Mr. Pinter, just could you explain the difference between, I know there's two phases that you could do it on the assessment side or on the director of finance side. Could you explain just one more time and clarify what those rules are if this ordinance were to pass and how that would affect a decision that we made? It's my understanding one would be done if the assessor chose to change the actual assessment. The other would be is that the assessment wouldn't change, but the director of finance would simply not bill them as much.
Essentially, there's, to break it down, 3 remedies. If you adopt this ordinance, you would be enabling 3 remedies. Number 1 remedy would be the assessor, under her already existing duties in statutes, would be able to clerically make an adjustment. Now, if that option were to be taken, the clerical adjustments can go back 3 years, can be done for 3 years. So there could theoretically be tax relief back to 2012, yes. Under the second option, which is the use of the state enacted legislation for properties, for residential properties which, in the opinion of the legislative body, you, have resulted in outside or excessive increases that are of such a nature as to impose harm on the taxpayers as factually identified, then the assessor would be authorized by you to adjust those assessments so that the taxes for the present year, the 10-113, would be no more than 3.5% of what they were in the previous reval. Now that could also go back to 10-1-2012. You could retro that one as well. Those 2 are in the assessor's jurisdiction. The
That
third-
exists now.
Sorry.
That rule exists now, the 3.5% rule. That
That's-
currently exists today.
That's the standard adopted in the state law.
And it's in-
Exists today.
So they have that remedy right now.
If the assessor chooses to invoke that remedy, you would give her that right to do so by adopting this ordinance.
But it's already existing.
No, you have to adopt an ordinance to allow her to do it.
But it's not in red, yeah, that's what I'm saying.
Yeah, the not in red, number 1 is the one that we're talking about right now, number 1.
Okay.
That's the statute that you would have to adopt by ordinance. That's why you need this ordinance.
Also, it doesn't exist today.
The assessor can't
Excuse
do it
me,
without.
point of order,
And-
Mr. Chairman.
and-
I still have
yeah.
Thank you. Mr. Pinter, if you could finish one, then I'll, 2 more follow-ups, and Mr. Cheese, you can have the floor at the chair's discretion.
Yes.
Mr. Pinter?
Yes, Mr. Wetmore, thank you. So, in answer, the assessor would have the jurisdiction in number 1 and number 2 for those remedies. The clerical, she already has it. The statutory, as provided by the state legislature, would be if you adopted this ordinance. The third remedy would be the remedy provided to the director of finance, where the director of finance, not changing an assessment, reviewing the assessments, reviewing the information, but theoretically and practically providing a tax credit or tax relief to remedy this apparent inequity. That's the director of finance authority that, again, if you give it to him through this ordinance, you would have that authority to do that. Those are the problems.
Another follow-up. Could you clarify, this is gonna sound ridiculous, can you clarify clerical? We're not talking about simply Scribner's errors here. The authority would be an actual, something that they felt would be an error or something that is misspoken. That would be the authority that's already established.
Yeah, Colleen and I over the years have talked about clericals so many times. Basically, a clerical adjustment is a non-substantive mistake. It's a mistake in number, it's a mistake in maybe missing a bedroom by accident. It's a clerical mistake, a pen or pencil kind of mistake, or a simple mistake of fact, as opposed to a substantive mistake. The law really says a substantive mistake is one that was done intentionally. In other words, the assessor or the revaluation company simply determined that this was the right way to assess the property. That's not a clerical error. Okay.
And my final question, you had mentioned that there's clear legal precedent for portions of, the new portions of this ordinance that have been established. You said you had an opinion, could you just elaborate on the opinion that you
Yes,
received?
yes.
Briefly.
This, yeah, there is limited precedent for the use of the statute that I referenced with respect to the state legislatures. That statute, just to give you a 2-second backdrop, was adopted in order to assist Hartford residents in the 1990s and beyond, whose properties were excessively assessed through, not intentional assessment, it just turned out that way. Similar to this, there was a finding that there was excessive assessments. As a result of that, it would have driven people out of their homes, required them to sell their homes or otherwise be financially harmed. So the state legislature saw fit to adopt this provision if the local legislature adopted an ordinance to enable it, to deal with that. Our opinion, an opinion that we have in writing, breaks down all of the statutory support. The statutory support for the Connecticut legislature's action, statutory support which already exists for the clerical adjustment avenue, as well as the statutory support for the local legislature's jurisdiction to authorize the assessor to do something in a way that provides an equitable solution to a problem.
Mr. Chairman.
David, I have a question for you. You stated before, if this was to go forward, the solution that you worked out, you said that 20 to 25% of the land value would be taken off, but that would still allow those property owners to go through the appeals process on the rest of their.
It would, and keep in mind that piece is contingent upon the assessor, because I can't adjust the assessment, but I can do tax credits.
Right.
But yes, they would still be permitted to go through the appeals process.
Joe, do you have a question?
No, the only thing I would say, Mr. Chairman, is that for years, this council has approved a phase-in of taxes after reevaluations and paper reevaluations with the effort and the design not to burden taxpayers with a one lump sum penalty or one lump sum increase in their taxes. And we did that for the same specific reason. I think that we're here tonight and looking at these 8 clusters and these 173 homes. And I would just urge you to truly consider this as a reasonable option to fix this inequity. You know, a lot of homes in Danbury received tax credit or tax break this year. And I don't really understand why some people, and I sat with Mr. St. Hilaire in his office about 3 months ago, and we looked at some of these anomalies, and people had some tremendous increases in their taxes at their properties, and it happened to be in these clusters. And I think it's our duty to offer some relief to that, and I encourage you, and I hope that you'll support the ordinance tonight.
Just to follow up on that comment. That phase-in of any increase is not part of this ordinance.
No, that wouldn't be considered as part of this. And keep in mind, we look at the, although the end result are taxes, it really is the equity of the assessments, because taxes are driven by assessments. Taxes don't just happen on their own. It all is the basis of assessments. And, you know, when you see on average the residential property tax, residential property types have declined by 25%, but then you look at, you know, certain areas and they have increased significantly, that is a pretty wide range. When you know that trend since 2007 is not to go up even in the best of situations. So it defies logic, and that's why, quite frankly, you know, from a numbers guy standpoint, I look at this and I scratch my head, you know, and I say, you know, and believe me, we don't, I don't want to give up anything, but I can't justify. I just can't justify, and that gets to the point where equity and uniformity comes in. And all due respect to the assessor's office, Vision Appraisals, they're a mass appraisal company, they're doing statistical analysis just like we did, and we did it 3 times, and they did it, and we came to the same conclusion, there's a problem.
And I still find, I'm having a hard time accepting this because I don't understand. I mean, I don't see how I just don't see how the savings are coming. See, there's a lot of, there could be a lot of conflict between the assessor's office and your office. Because one says it's spot assessment, and I can see her point, that it can be viewed as spot assessment. So if she's not gonna back certain parts of this ordinance, and then you're gonna offer a tax credit, so there's still gonna be that inequity between the two. So my, again, through Corporation Council, what other options are there besides this ordinance? Is there anything for, can we create some type of tax zone just for the lake and just say, you know what? We're gonna do a mill rate of you saying being 26 to 24 mil, 0.24, where that 2% decrease can give an equalization to where it's about equal between everyone else. So, I mean, and that's something that's uniformly applied, it's the same assessment, we're not playing with assessment, we're just playing with the mill rate. So if their mill rates go up, 50% higher than anybody else, but we give them a lower mill rate, so it kind of makes it more of a balance, and you can budget that.
Right.
You can play with that budget, so you can play with that equalization of the mill rate,
Yeah.
is really what we're talking about, because that's what caused a lot of this. It wasn't the assessment, because we all love high assessments, we all like that, but we don't want to pay the tax that goes with that high assessment. So it's really the mill rate, is that doable? Can the council do something like that? Is it in the state authority for us to do that?
There's a few questions in there, Ben, through the chair. As far as creating segments, what we're dealing with here is clusters of specific harmed properties, and that's what we have to deal with. The remedy is hard enough as it is, because again, it has to be said clearly on the record that in 99.9% of the cases, people who feel that their assessments are too high or wrong have a remedy that's statutorily automatic, which is you go to the Board of Assessment Appeals. Actually, in this case, for this year, the problem for most people was that they didn't know what their mill rates were going to be in the phasing issue until after the opportunity to come in to the board had passed. People could come in this year in March to contest their 10-1-13 taxes. You can do that. That's the remedy that's available. This problem is very unique, so to craft additional remedies would require some peril, because when we looked at the available remedies, these are the ones that we found after very careful examination. Doesn't mean we didn't miss something, but in order to not to create a situation where we are setting out all new assessment law and providing remedies for everybody who comes in the door, this is a extremely unique situation for an extremely unique set of clusters, and it's the only way that we believe that the administration of this remedy could be supported, and that's through action by the council in this way.
Andrew.
Thank you, Mr. Chairman. Just to Mr. Pinter and to David, this ordinance is simply giving the tools to certain departments to act if they feel necessary. Later would come the actual means, the actual how it would be implemented on a case-by-case basis, correct? It's simply getting the tools first, and later would come, all right, this is how we're gonna figure this out, so then it's not, you're not simply just allowing the assessor to say, all right, you're good, you're getting screwed, so on. Then it's gonna be, we're gonna be blunt about it.
That's exactly right.
It's giving the tools to start with. Later is gonna come the actual implementation, but obviously you can't do that until the authority is there to allow them to figure that out. Correct?
And if it were otherwise, this panel would be essentially the hearing body of the Board of Assessment Appeals, and you couldn't do that. So the best you can do is to adopt a toolbox to allow for the people who can administer the remedy. That is what you do.
Thank you, Mr.
Mr. Hearn.
Mr. Cowell.
Thank you, Mr. Hearn. If I could just respond also to Mr. Cheney's remark. and Mr. St. Hilaire, you could probably chime in on this if you would, please, but the issue was there are anomalies here. There are houses that got a 44% increase in their assessed value, and houses across the street either remained the same or dropped in some cases. And not having unusual property issues or not having unusual additions or things like that. And that's what this is trying to address, is the anomalies. Why did that happen in certain homes and not in others? So to create a district, it may not have to be as widespread as creating a Lake District. It could just be isolated down to these clusters that can get looked at and hopefully get addressed. So I hope that helps you a little bit there with that.
Yeah, as I mentioned earlier, there's about 800 to 900 properties on the streets that we're talking about. You know, I think overall, there's no easy or clean solution to this. You know, we batted this around and we you know, screamed at each other about our own, you know, guiding principles about our positions and all this other, but the bottom line is there's just no simple solution. And that's, you know, the attorney's office have really looked through everything to see what will enable the city council to provide some kind of remedy to the situation here. And that's, you know, we didn't want to just broad stroke it and say the lake property, because quite honestly, we did talk about that very early on. We said that, you know, that may create more problems than what we're trying to solve. So, you know, so that's basically it.
Mr. Chairman, can I just
Sure.
advise the committee on one item? I know that the assessor. The assessor had mentioned a concern about spot assessment, and Mr. Cheney's brought it up. I just wanted to say I understand what Colleen's concern is about that, and she's always proceeded in duties with the highest honor, dignity, and respect and professionalism. The spot assessment issue, however, is overcome by the tools you have in this ordinance, because the legislature will then see fit to have recognized that this remedy is not spot assessment, rather it is a remediation of inequities or inequalities that the legislature of the state has authorized. And that is your enabling protection for that. So that concern is understandable, but we believe this provides a remedy for that.
You know, if I may, through the chair. Sure. I mean, probably the ideal, once this is adopted, still the ideal path would be for those that have a concern to go through the, you know, Bureau of the Board of Assessment Appeals. And then, based upon the end result of that, we can, then that's where I kick in and say, all right, we can adjust for the current year based upon that. And does that make sense, Council? That, you know, the board has done their review. You know, Colleen is not put into a rather uncomfortable position, which she has stated. The board has reviewed it and have deliberated and come to a conclusion, and based upon that, I can then make an adjustment to tax credit for the current year, because that is just going forward. That would not take care of the current year. That's another. I mean, that's the ideal way, but it may, you know, people may feel otherwise.
All right, what I'm gonna do now, I think we all kind of agree, the city's already admitted there's anomalies out there, and we're not gonna deal with the anomalies. The city's gonna deal with them. We're here for an ordinance, but what I will allow is I'll let some people from the public speak if they would like to speak, knowing full well that we're not gonna solve your problem. We're here for the ordinance, but they are admitting there is a problem. So, sir, go ahead.
Okay, I think there's an elephant in the room, and the elephant in the room is the vision screwed up. Now, in my case, in 2011, I bought out my wife and I bought out my sister's half interest for $688,000. We are assessed at $962,000, which is 40% high. My neighbor here had his house listed at $695,000. Zillow appraised it, he was unable to sell it. Zillow appraises it at $614,000. The Vision has appraised it at $832,000. Now, these are hard comps. And then, and I have to tell you, when I bought out from my sister, I was interested in overpaying her, and it was based on realtor's appraisal. Now, so I think what you're doing is praiseworthy and well, it's well considered. But I really think that it's putting a Band-Aid on a screwed up appraisal, and you're trying to. It's a hard way to go. I don't think you can get it right. Now, we do have the other assessment. Thank you.
Mike?
Through the chair. Ben, you have some.
Just a point of order, just for the record, we just need to get that person's name.
Oh, yes, okay.
If you could
My
state
name is
that.
Andrew Holt, and some of you have this.
Yeah.
Does anybody have what I distributed? Okay. So do you want it?
You should go to the chair. The secretary, the secretary.
Anybody else?
No, I passed them out. Yeah. Yeah, everybody state your name and where you live.
Michael Cowan, 16 Lake Road. Thank you, through the chair. I'm used to these systems. I was slammed 60% in 2003. I'm up 400% from when I moved in, 400%. I first got involved with this when I started speaking to Les this summer. And so I'm gonna have to move. I'm on Social Security now. I can't afford this any longer. I did some real hard analysis here. Ben, David, you made some good sense. It's supposed to make sense. And you made some good points. There are homes on King Street assessed for what my house is, rather appraised for what my house is appraised for. Their taxes are less than half. Believe that? Less than half. Got one house, 4 houses down from me. He's got 5,100 square feet. He's got about 500 feet of lakefront. It's contiguous lakefront. He's got an outbuilding in Cabana, and he's got about 1.25 acres, 1.5 acres. He's paying $25,000. You got that? My house is 950 square feet. I have 0.17 of an acre, all of which is not usable. I have no backyard, no front yard. I have a road in front of me, and the rest of it belongs to the power company. My taxes are looking at $13,000. So if he's got 7 times house that I have, and he's got 7 times the amount of land, and it's contiguous, why am I paying half his tax? There's another house just sold around the corner from me, in Cliffwood. Sold for $599. She's got about 1.5 acres of land. The house is bigger than mine. She's got western exposure. The land goes, it's contiguous. It goes from the lakefront all the way up to Stadley Road. My taxes are higher than hers. It makes no sense, David. It makes no sense. Now, I had a conversation with Colleen earlier in the week when we were talking. And Colleen says, well, you know, you live on the lake. When I look outside my window, I see a building and a street sign. You see water. You should pay. So, you know, I know where she's coming from. And I think that the whole system is being corrupted by subjectivity and by resentment. And that's what I feel. Because I've been slammed for 17 years. Every 5 years I get hit. So this 32% to me is an anomaly. I've had anomalies since I moved in. And as a result, I have to sell my house because I can't afford to live there anymore. That's all I have to say. And I have the facts right here. It's not subjective, they're real, they're actual. So, thank you, gentlemen, for listening to me.
Sir?
Well, my name is Mark Littman. I'm at 18 Shore Road, a neighbor from Mr. Holt. And I'm the one who tried to sell it, but couldn't. I submitted some information earlier to you all. I'm not going to regurgitate that, and I've edited my prepared remarks based on what I've heard so far. We did some analysis, and just to kind of emphasize this divergence in the valuations. We recognize that lakefront property comes at a premium, and the prior valuation recognized that through land values being valued 2 or 3 times the land literally opposite on the other side of Lake View of the same streets. I did some research on the 3 waterfront roads. This revaluation takes that multiple of 2 to 3 and exaggerates it to 4 to 5. The reval on Shore Road, the average land value increased by 28%, and the Lake View property land decreased by 17%. And that's the anomaly, and I was cheering silently when Mr. St. Hilaire confirmed that their analysis and Cushman and Wakefield's identified these anomalies in the root cause of what appears to be a divergence in the values of the land. And so that the recommendation that's coming from the outside consultant, Cushman and Wakefield, to adjust the land values by 25% or so. I haven't seen that proposal, but that sounds about right to me as one observer. And I would encourage the committee to consider really addressing the root cause, which is in these land valuations, not through a Band-Aid of, I'm going to give you a tax credit this year, or phase in the pain, which ultimately would yield, this an excessive outcome and inequitable distribution 4 years from now. Thank you.
Mr. Whitlock?
Thank you, Mr. Chairman. My name is Robert Whitlock. I'm the president of the Danbury Yacht Club located at 20 Hastetown Road. And from what I've been listening to, it seems to me, and please through the chair, anyone can answer my question, that this ordinance is primarily focused on residential. Am I correct, or will it? I know Poets Landing was mentioned. That is directly across the bay from our location. The reason that I'm here, and we have already gone through the Board of Assessment and Appeals back in last March, appealing the assessment. Our grand list assessment going back, and I'm going to do this very quickly and not take everyone's time. In 2007 on the grand list, Vision Associates had put it at $829,400. Through the appeal process and through a visit to the property by the tax assessor at that time, it was determined that the land was being valued as a per unit land value, which apparently was incorrect, and the assessment was reduced to $550,000. In the most recent revaluation, we have gone from the $550,000 to $932,600. That in itself is a 70% increase. And then with the mill rate increase, our taxes have gone from $13,000 to over $25,000. That's a 93% increase in 1 year. We're not a commercial marina. We don't own the docks. We don't rent the docks out. We don't have a restaurant. We don't have a bar. We don't rent our property out or the hall out for outside use. And I realize that tax exempt does not apply to property tax, but we are recognized by both federal and state as a nonprofit 501c7 tax exempt organization. I guess my question is, having gone through the appeals process and been denied, and looking at an increase in taxes of 93% from what they were a year ago, is this ordinance something that we're going to be able to work through to remedy our situation, or do we have to start all over again? Where do we go? Through the chair to perhaps Mr. Pinter, or?
You want me to answer that? The answer is that it's possible, Bob. The only remedy that's not available is the first one, which is the one using the state law.
I understand that.
Because that's residential or apartments.
Exactly.
You're probably gonna fall in there. If a clerical adjustment were made, yes. If the tax credit adjustment were made, yes. Your third remedy is to go back to the board this year, but that doesn't address you for the 12. So the only way to do the 12 is 2 of the 3 that are proposed.
It just, we're a good sport, and we understand, we have 50 members, 36 of us are residents of the city of Danbury. Some of us, myself included, are lifelong residents of the city. We're not trying to duck our responsibility to support the city and to pay our fair share. However, a 93% increase seems totally unreasonable. And I don't know if this ordinance is the avenue. I'm just looking for some guidance. Where do we go from here? Do we have to go back to square one through the tax assessment, which they gave us a hearing, and a week later we got you're denied.
Through you, Phil, in the yacht club's case, there's one difference between yourself and I think most of the other people. I don't know if anyone else went to the board for the 2012. You did.
Yes.
Right, but most didn't. So the fact that you were denied relief by the board may be a factor in the inability to get a remedy, but probably you could find yourself in the same class as even those who never went to the Board of Assessment Appeals. But it's a little different because you did go, so we'd have to look and see if statutorily someone who went to the board could get, if you will, a second bite. We'd have to kind of look at that. So right now, I could only say through you, Phil, that we have to look at that and see if, by having availed themselves of the board, whether that could possibly exclude any other remedy. I'm not sure.
Does that, again, through the chair, any other folks here who may have already gone through the board as we did, does that put them back to square one as well, or does this cluster arrangement? I guess my question is, does this, the occupancies that you've targeted through this cluster, do we fall into that, or are we out here somewhere else? Because I'm sure there's other residents here who have gone through the appeal as we did, but they may fall under this new ordinance. And I guess my question is, do we, or do I have to go a different route?
To Phil, if you fall in that cluster, which it seems like, I'm not sure, not seeing the name on the list, but if you fall in 173, the class of 173, if you will, you'll be able to avail yourself of these remedies unless, since you went to the board and the board acted, it's possible that legally you may not have a remedy. But I don't know that for sure, because those handful of situations create a new question, which is if you got a remedy, a negative remedy, if you will, from the board, it's very possible that that may be the only remedy. But for right now, if the ordinance is adopted, that would be looked at, and that remedy, it could be made available possibly. I just don't know. That's an issue that really we have to look at.
Will he go to you to look at it, or?
Well, I've made a note.
Okay,
okay.
Good.
Thank you,
Sir, go ahead.
Robert Howe, 20 Lake Road, Driftwood Point. I went through the process after getting 2 assessments, one in November, I believe it was, and it put mine down about $19,000. I said, that's not too bad. Well, got another one January 1st, went up about $10,000. So I was net down about $9,000. And then when the mill rate was announced there, I had almost $3,000 extra in taxes. Now, before that point there, I went to the appeals board, if you can call it that. But I gave a statement on the appointed date that I went in, and I didn't have any feedback, backs and forth, ask questions or anything like that. My biggest argument was why my land rate was so much higher than 4 houses down, waterfront, no easements or anything like that, basically flat, but his land rate is much lower than my land rate. So they didn't seem to see it, that was and I was denied my appeal. So anything that you can do. And I do, my wife and I are both retired, and we're on Social Security and pensions.
Peter?
Thank you, Mr. Chairman. Thanks for your time tonight. I know some of you, this is the end of the week. I do appreciate the extra hours that you're putting in. I had a lot of time to think about this. I'm a resident in Danbury at 49 Saddle Rock Road. And since the meeting where I watched on TV and saw Mr. Winter, I believe, complaining about the increase in his lakefront property. And there's a couple things that have taken place, and I think it goes to what Colleen had said earlier. Back in April, when the budget was proposed last year, I think everyone was excited to hear that 60% of the community was going to go without a tax increase. And I think that was followed up in May by another article, and you should learn by reading articles in the paper, I guess, that a $300,000 house would see about $149 in increase in taxes annually. I think a lot of people like myself put faith in my bank and my escrow account and said, you know, they'll take care of it. And imagine our surprise when that $149 annual increase turned into $1,000 for the year. I thought maybe somebody made a mistake with the zero. And I listened to the debate as things were going on and talked to neighbors. And I don't live in one of the pods or whatever. I live on Saddle Rock Road. My waterfront property is Upper Cohanza, a reservoir. And talking to my neighbors, many of their properties went up substantially. And I thought about the popularity of what you're doing here. We've got people on the lake who are talking about paying too many taxes. A guy on a dead end with a reservoir in his backyard whose taxes increased. And I applaud what you're trying to do, because many people would say the property tax system is a regressive tax, and you're asking people, some of which have the means to pay that tax, to reduce it. And I think we're missing a bigger picture here. And in talking to my neighbors, I can afford, in my position now, $1,000 a year in taxes, I'll be honest with you. But I've got neighbors who are widowers who are on fixed income, who are gonna have difficulty paying their taxes. So $1,000 a year is almost $100 a month. That's an electric bill, that's food on the table with people. And I think we miss the pressure we put on people with fixed incomes. And there's gotta be a better way to do it. And I think just fixing a certain area isn't the answer. I think Colleen is right, there's a mechanism to deal with that, but it's a much broader picture that has to take place. There's circuit breakers now in place where elderly on certain incomes, low income families get a break. But it doesn't apply, I don't think, to the middle class that's struggling right now. So there's gotta be a way to leverage those circuit breakers so that this anomaly that's taken place, I go back to vision appraisal and I tear them and rip them a new one, to be perfectly honest with you.
Yes.
If you go to their webpage, they'll be the first to tell you, and it's in writing, that they hear all the time, waterfront property does not impact their assessments. Obviously it does. So their formula did not keep pace with the property valuations, whether they were up or down. Their assessment, their appraisal does not equate to fair market value of what's out there now. There's one house that was for sale on our road, a cul-de-sac. 25% less than what they bought it for several years ago. 20% increase in taxes. It's now off the market because even at 25% less, they weren't able to sell the house. So I don't know that locally you can deal with this. You can try. I think this is not a popular endeavor that you're going to do. You're going to talk to the rest of the city about trying to make or fix anomalies for lakefront property, cul-de-sacs with reservoirs out in the back.
You know, something's gotta be done to assist the middle-class people, the people on fixed income, the young families that are struggling, the single-income people that are out there. And if you need to get to the state legislature and talk perhaps about some sort of homestead benefit for Connecticut that we don't have now, something that gives the people in the community, who have been here in the community, a reason to stay within the community. You don't farm them out or push them out the door over the state lines because they can't afford to live here anymore. These are the people that made the community what it is. Danbury is what it is now. It's not a suburb. It's always been an exurb of New York City. People came in here because they were forced out of the cities. I don't want to see the city of Danbury be in a position to push people out to those suburbs. We do that, and we're left with declining funding for school and education. Public service is going to suffer, and ultimately we become a shell of a large city again. And Danbury is much better than that. So I applaud the effort that you're making. I thank you for your time. I'll pay my increase. And I would ask you long-term to think long and hard about what you can do for people on fixed income, people who are struggling out there, because we're missing the mark totally. Thank you.
Thank you, Mr. Chairman. I move to recommend the adoption of City Ordinance 18-29 as proposed for the application of the assessment and/or tax relief to those affected property owners deemed inequitable impact by the October 1st, 2012 reevaluation or by lack of available remedy for such inequity in a manners set forth in the ordinance.
Try your minds, all in favor?
Need a second, Mr. Chairman?
Oh, you got a second?
Can you read that again?
Yes. I move to recommend the adoption of City Ordinance 18-2 as proposed for the application of the assessment and/or tax relief to those affected property owners deemed inequitably impacted by the October 1st, 2012 reevaluation or by lack of available remedy for such inequity in the manners set forth in the ordinance.
I'm gonna second it so we can discuss it. So I'll second it.
All right, open discussion.
Mr. Chair, if I
Go ahead.
may. The question, the motion was that we recommend. Should it be that we recommend to the council as a whole, and also be subject to a public hearing? Isn't that the goal here, is to send this to council for them to recommend a public hearing?
You'll, through the chair, you would do that as a matter of course when it is received by the full council. So your recommendation is understood to go to the council at the next meeting, at which meeting, as typically with referrals, since with any other ordinance, including this one, it would be referred automatically to a public hearing at that point. So you don't have to say, you don't have to say it in the motion. I mean, you could, but you don't have to.
I just wanna make sure it's clarified that we don't.
Right. It won't slip through without those processes.
Any more comments?
Yes. Thank you, Mr. Chairman. Just one quick question to either David or to the assessor. Vision appraisal, is that a contract that goes out to bid that we use them? And they are pretty much typically the only one that comes in? Is there a couple companies out there, but it is out to, we put it out to bid, right?
Yes, we do.
Okay.
And there are other companies.
There are other companies that come in and bid, and primarily they're usually the ones that do most of the municipalities in the area traditionally.
Currently.
I'll be the first one to admit, I mean, the vision appraisal, we have tax appeals all the time. No one is always thrilled with what they get. I do have to admit, there is a certain level of sympathy that I don't have for a lot of the folks that simply you're lucky you live in the nicest spots in the city, in the state, maybe in the country, and you have one of the most beautiful pieces of property. That doesn't mean you should have to pay more on something that isn't necessarily valued equally. To address some of the issues regarding the middle class folk, I think you're right. But I think that we do a pretty good job at ensuring we keep things as low as possible. I think everyone in this room would recognize that no one here really anticipated such a large spike in some of these neighborhoods. And certainly we never voted in a manner of which we thought was going to intentionally raise things at such a dramatic rate. I think we were all just as surprised as you were and just as appalled. It's never been our intention to remove anyone from the city. We know there's a lot of folks on fixed income. Mr. Calandrino, as you know, when you've been in my seat, you know, I held it after you. Our hands are tied in many steps of the way, and it's just as frustrating for us. I support this. I don't know necessarily if it is the best means of accomplishing this. I think it's the means that we have in front of us. I certainly wouldn't want your job. God bless you. I think you have the hardest job in the city. But, you know, whether or not these mechanisms are utilized, either by current departments or future departments, they're there to try and right a wrong of which we didn't really intend. So I hope you take that for what it's worth. I don't think it's perfect, but I will be supporting this and hopefully supporting it when it goes to the full council to try and provide some sort of relief, if any, to those of you out there. Thank you, Mr. Chairman.
Chairman, it's really quick.
Go ahead.
Again, I second the motion, so we have this discussion on the table. Again, I'm still not comfortable whether or not this is the correct answer to what's going to help the people in the audience tonight. But I do agree, the more communications we can have, the better we can make this ordinance. So that's why I approved and send it to the council as a whole, send it to a public hearing, and let's just hear everyone's concerns of this, understanding this ordinance, whether or not it will be successful, which I hope it will be, to solve some of those issues that are raised, but at the time, I just don't have enough knowledge in front of me to whether or not this will actually succeed or not. So I think if we move it forward, this way we can put it on a bigger scale, and hopefully we'll get more of your residents to come down. And we stress that, get as many people down here so we can hear the whole picture, and not just pieces.
Okay, we haven't voted yet. All those in favor?
Aye.
Aye.
Aye. Opposed? No. All right, roll for adjournment.
So moved.
Second.
Aye.